welcome everyone to our Friday colloquium this week. This week, our speaker is Ryan Calo. He is the Lane Powell and D. Wayne Gittinger Professor at the University of Washington School of Law. He's a founding co-director of the interdisciplinary UW Tech Policy Lab and the UW Center for an Informed Public. Professor Calo holds adjunct appointments at the Paul Allen School as well as the University of Washington Information School, and his research on law and emerging technology has appeared in leading law reviews and technical publications, and he is frequently referenced by the national media. His work has been translated into at least 4 languages, and he has testified 3 times before the U.S. Senate and organized events on behalf of the National Science Foundation, the National Academy of Sciences, and the Obama White House. It's our pleasure today to welcome him to our colloquium, where he'll be speaking on the automated administrative state. And as in previous colloquia, please feel free to post your questions in chat, or you can unmute yourself at the end of the presentation. But Professor Calo will also be asking questions during his presentation, and I encourage you to participate. Professor Calo.
Thank you so much. Thanks a lot for inviting me to your colloquium. As Denise said, I am a law professor, and we have a different set of norms when we teach and present. So first of all, in my case, I really almost never use PowerPoint, and so if that's going to be strange, I apologize in advance. But that's not a norm in my world, actually, in the way that I've seen it in so many other departments. And the other thing too is that you may or may not be aware, but in law school we use the Socratic method. And so rather than me standing up and speaking to my students at length, I often will lecture for a very short time, just a couple of minutes, and then I'll start to ask my students questions. And so I may throw some questions out there to you that will wind up, either you'll answer them in chat or unmute yourself and answer them, or I will treat them as rhetorical and I will myself answer them. But anytime you want to ask a clarifying question, please jump in. It's wonderful for us to talk across disciplines, but it sometimes means that we need to be really attentive to the concepts and language that we use, because terminology or ideas in my field may play out very differently or be absent from yours. That said, I've had a wonderful history with your department, having collaborated with several of your faculty, some of whom are on this call, and also co-authored and helped plan conferences and the like. And I've been on a number of PhD committees in this unit as well, which I absolutely adore doing. So, if you're looking for like a GSR, I'm your person. So the talk today is concerning my work around automation in the administrative state, meaning typically federal, but also state agencies. So this would be like the FDA or the EPA. It would be like Department of Health and Human Services for the state of Washington or for the federal government. And the idea is how are such agencies using automation, and what are some of the consequences for law and legal institutions that they're doing so, okay? And so the example would be that a state decides that it would like to automate the process of determining disability eligibility, or to use an algorithm to assess compensation for teachers, or use an automated system to detect fraud. These are all uses of software, in essence, to automate a function that had previously been reserved to human people. And this idea that automating the tasks of government officials through software would imperil values and legal precedents that we care about has a long history. And what has happened over the years is that law professors like me and others have written about the way in which if you automate something, if you automate a decision that is consequential about a resident or a citizen, and they don't like the outcome, then the question is whether or not the individual or group is in a position to challenge the automated decision. And historically, the way that we have talked about it in the legal academy has to talk about how you can deny people due process by using algorithms or automating a decision. For example, say that you are determined by an algorithm not to be eligible for parole, or you're recommended to be detained pre-trial before you are ever found guilty of a crime as a result of an algorithmic system. The question then becomes, are you really in a position to challenge the fairness of that system? And there are a number of impediments. Perhaps it's hard for you to understand how it works. Perhaps the people that are administering it don't even understand how it works. Maybe something about it is proprietary. And so some company that built the system for the government won't give you access to its code or its databases, citing trade secret protection. The question then becomes, are you really in a position to challenge adverse decisions on the basis of automation? So that has been one line of reasoning, and a bunch of people have written about it. And again, the basic idea being, if there's a decision about you that's consequential by the government, using software and algorithms or algorithms, are you able to effectively challenge it? And if not, then do you really have the due process that the Constitution guarantees? Another line of reasoning is that there are federal laws that require that if an agency, like a federal agency, makes a new rule, like for example, we're hearing about OSHA and how OSHA is requiring certain kinds of COVID safety rules, and then being challenged in court. The basis of the challenge is the idea that not enough public participation went into fashioning those rules. So typically agencies are required to do something called notice and comment, where they tell the public and any stakeholder, hey, we're thinking about this new rule, and the public gets a chance to weigh into those rules and to talk about their wisdom and maybe what the agency could do differently. And then the agency has to take into account that public input before making a final rule. And so another basis for challenge of automating government functions has been that when you automate something, when you take a legal standard and you try to reduce it or render it into a software, then sometimes you subtly change the rules. You have to make decisions about cutoffs, and you have to make decisions about what words mean. And all of a sudden you're taking a standard and you're committing it to software, and you're doing it through a process that is completely obscure to the public, in which they have no input. And so a second line of argumentation has been that to reduce rules to software sidesteps required process from the standpoint of notice and participation. Okay, and so these things have been said for a long time. There's stuff in the 1990s by Paul Schwartz from Berkeley about this. The really big paper is Danielle Citron's technological due process. And so people have been talking a long time about how once upon a time you used to do something with a person, and now you're doing it with an algorithm or software. Do you really still have the same safeguards and guarantees in place? And what needs to change about law or code or anything in order to bring us back to the status quo ex ante when you could challenge things or you had input into it? So the project that I'm talking to you about grows out of that literature, but it takes a different strategy. And it's co-authored with Danielle Citron, who is a law professor at UVA and one of the original authors to tackle this set of questions decades ago. She also, it was sort of a little surreal, but in the middle of our writing together, she won a MacArthur Fellowship, which was slightly surreal. But she's a really prominent law professor, and she's my co-author for this particular piece. And in it, Danielle and I kind of take a step back, and we say, okay, well, all the stuff that's being said about automation in government is all true, and people have written about it, including especially Danielle. But gosh, let's take a step back and look at some other aspects of this problem. And simultaneously, we had the benefit of access to a bunch of lawsuits that had challenged algorithmic decision making. And so around the time that we're thinking about what else can be said in this space, we're able to review like 10 years of various very clever attorneys challenging adverse decisions made by algorithms, made by software, especially among state agencies. So we actually see how the automated administrative state has been playing out in practice. And I'll tell you, the picture is not pretty. It's not pretty. There were situations where, as one attorney, a guy named Kevin Delaban, who's been very prominent in the space, has characterized it, there's been some algorithmic absurdities, as he put it, right? The kind of thing that you and your students, you wouldn't let each other do. So for example, there was one, this is the example that leads out the paper, but there was an example where a state decided that it was too expensive and maybe even a little bit subjective and unfair to send nurses into people's homes to determine how much in-home disability services the differently abled have in that state. So the idea is, once upon a time, you had nurses go into people's homes, and he or she or they would ask a bunch of questions of a person who was living with a disability and try to ascertain how many hours a week does this person need of state provided service in their home. So they decided, you know what, we're gonna dispense with this system, and instead we're gonna have them fill out a kind of questionnaire, and we're gonna compare that to a database that we have, and then we're going to have a system automatically recommend the amount of in-home care that they get, and then that's what they get. And so, as you might imagine, it did very much fundamentally change the amount of care available. And as you might even guess, it dramatically reduced the amount of care in many instances. These people were having this lived experience where they had adequate care, and then all of a sudden, they suddenly had not enough. And so they were upset, and they complained, and they challenged it. And what was so interesting was that the people that had implemented the system and were ostensibly managing it could not explain why the system had decided the way it did. And so very careful attention by like lawyers and paralegals and some technologists began to unpack precisely what had happened. In one instance, for example, and this is where the phrase algorithmic absurdity comes into play. In one instance, the system had recommended that a person whose foot had been amputated due to its condition, that person be recommended to have fewer in-home services because they no longer had a foot problem, right? And so it's the kind of thing that would be like funny were it not someone's actual real life who was dealing with this. And they found all kinds of things like that, right? And so overwhelmingly, what Danielle and I saw in looking at the lawsuits against the various states, and including some challenges to federal systems like the no-fly list and the complicated algorithm that goes into whether you end up on the no-fly list, time and again, we found the following pattern. There would be a mistake, and nobody in the ecosystem understood the system well enough to describe how it happened, overall or in the particular instance. And so time and again, you have these government officials who are being deposed, which is where in a trial, you're asked a bunch of questions by opposing counsel in advance on camera to write down your answers and to get a sense of what you'll say at trial. or they're on the stand in front of a jury or in front of the bench trial or in front of a judge. And they're sitting there, these government officials saying, we don't understand how this works. We're not sure how this happened. Okay. And this happens again and again. So, so what this causes us to start to realize is that these systems, not only are they making mistakes and ultimately probably costing the states a lot of money, but they are fundamentally undermining the very justification of the administrative state. Okay, and that's why the sub part of our article is the automated administration's a crisis of legitimacy. They are undermining the legitimacy of the agency. Okay, and this is a departure from the previous literature that had focused more on what are your individual or group rights to challenge adverse decisions. This was more of a big picture. Why do we have an administrative state in the first place, and how does automation and software affect that picture? And so this is the first time that I was aware of, although people have looked at it since, that there was a real examination of how automation affected the very structure of government, the very dynamic. And to explain that to you, I'm gonna unfortunately need to give you a small lesson in administrative law. Not unfortunately, actually, administrative law is fascinating, but to me, maybe not to you or to my students always, but I have to give you a little lesson in administrative law to explain to you why what we were seeing, the pattern we were seeing within state agencies' use of automation undermine legitimacy. Okay, and so the first part to understand is that agencies, the idea that there would be these giant bureaucracies that would like govern every aspect of our lives, like the EPA and the Department of Homeland Security and this and this and that, was not part of the original constitutional structure. Right? So if you think about the original constitutional structure when we were setting up the government, hundreds of years ago, the idea was there'd be three branches of government. There's the legislative, which is by far the most important, which is supposed to write the laws. There was the executive, which is just supposed to execute the laws that were written by the legislature. And then there was, of course, the judiciary, which was supposed to interpret those laws. In many ways, you can think of it as like, it's an important way to divvy up power by separating the types of powers that the government has. You often hear the term separation of power. It's not really separation of power. It's not just moving power around the government. It's separation of powers. That is to say that each branch of government has a different role, and they have to rely on one another in order to govern. It's not just that the government, it's not just that like some power resides in the federal government and some in the states, and some resides in this and some in that, some in the House, some in the Senate. Rather, they have different jobs. And so it's much more like the fates in Greek mythology, where one of them spins and one of them measures and one of them cuts. In Greek mythology, the reason that the fates are distributed that way is because that is a very extreme power, and the gods were not comfortable giving it to one person. And so they have three different entities who all have to work together. That's how the government system was created. But then things got real complicated real fast. And so all of a sudden, society and industry became enormous and complicated in a way that it was just impossible for Congress, the idea was, to govern. And so Congress had to begin to create these agencies that would carry out the day-to-day governance in particular areas. Okay, so that's how we got, it's not really possible for Congress to write a set of laws for banking, for telecommunications carriers, for the airline industry, whatever, and then expect that the executive under one common umbrella would just enforce them all, right? That original idea that there'd be like just basically a law and then a prosecutor of that law, and maybe we'll talk to the courts if we need interpretation, that model didn't work, come the Industrial Revolution. And so the idea was that we need these giant agencies, and they are justified under the constitutional system, though they are extra constitutional. They're justified on the basis of their ability to do what Congress can't. Okay, and so the idea is that we justify creating giant agencies like the EPA on the basis that Congress can't get the relevant expertise that is necessary to do environmental protection. And that in fact, what we need instead is a group of people who are specifically expert in environmental protection. And they're the ones, and then what Congress does is just basically give them some general orders, like this is your province, this is your powers, this is what you're supposed to do. But then the EPA turns around and it writes the regulations and it enforces those regulations, and it even interprets its own regulations through administrative law judges. And you see the problem with that arrangement. All of a sudden, first of all, Article 1, right, has committed powers to one entity, Article 2 to another, and Article 3 to another. So Article 2 has committed power to the legislature, and then the legislature is taking that constitutionally derived power and it's recommitting it to an agency that has no description in the Constitution. So it's taking its own power and it's giving it to someone else, which is the idea of delegation. And the second problem with it is that these agencies are mixing together powers that were supposed to be separate. They're writing the rules, they're enforcing those rules, and they're even interpreting them. And yes, they have some supervision by Congress. And yes, ultimately, you can appeal an administrative law judgment outside the EPA into the court system. But in the day-to-day governance of society, they're the ones that are doing all these two things. They're all three fates in one in a particular domain. How do you justify that? Because this idea, this arrangement was vocally challenged. It still is challenged today in the legal academy and elsewhere, where we say, this doesn't seem right, okay? And the prevailing justification for the administrative state was functional, from the meaning, pragmatic. Yes, it's extra constitutional. Yes, it has these dangers the founders were worried about, but we need it. Because we need these agencies to be repositories of expertise, and we need them to be nimble and responsive and have discretion, because not only is the world very complicated and requires expertise to govern effectively, but it's very dynamic, and it will move and move around and so on, right? It'll change, and so we need them to be nimble and we need them to be expert and so on. And so what we observed, Danielle and I, was essentially that, gosh, it seems to us that in automating the basic functions of government, these agencies are throwing away that very expertise and that very discretion with both hands. They're taking the mandate from the legislature that created them, who told them, hey, you need to understand the space you're working in and you need to be nimble and dynamic, and we need you to do this because otherwise we don't have time. And then they're overwhelmed, or for whatever reason, they are then recommitting that expertise and that discretion to software that they do not understand and that they cannot change. And so the idea is that if this trend continues and we continue to automate and automate and automate, not only does that present the kinds of problems that scholars have been writing about for a decade, wherein you need to challenge that you can't challenge the adverse decisions by these systems because they're inscrutable and intransparent and so on, but it undermines the very rationale for having an administrative state. And it's just the stark contrast of knowing, as a law professor who teaches administrative law, that the reason that it's okay for that public official to be doing what they're doing is because they're supposed to be an expert. And then when you put them on the stand, they cannot explain in the most basic way how it is that they're doing their job because it's being done through algorithms and software. It's that contrast that led us to write this paper, which has been, I would say, well received in the community. I mean, I think there hasn't been extraordinary disagreement with the basic premise among the legal academy, although people have certainly had their quibbles with how serious a problem it is, and so on. So, you know, I did promise that I would sort of give you a taste of the Socratic method. I think it might be a little hard, as I am, unlike when I'm in my classroom with my 90 students, all of us together, I'm obviously facing mostly a wall of names. And so I can't feel comfortable necessarily calling on you, but what I'm gonna do is the following. I'm gonna ask, you know, what are the options? Say that Danielle and I are right, and that this is not supportable, and that if we extend the process of automating government functions, like deciding who gets disability benefits, or deciding who gets to fly on a plane, or deciding what chemicals are going to be outlawed and at what amounts, or et cetera, et cetera, et cetera, et cetera. We begin to automate all those things over and over again. And assuming that does create a legitimacy crisis, and courts no longer permit this arrangement, this extra constitutional arrangement, I'd love for people to put in the chat, if you're willing, what are the options? What could you do in response to that? What are the things that how could you address the problem as I've laid it out? What are the possibilities? So Scott says split rulemaking and enforcement. Split rulemaking and enforcement. Yeah, that's a possibility, right? You could decide to address one of the two key issues here, and stop allowing agencies to contain both the ability to make rules and the ability to enforce those rules. Okay, and that would begin to address one part of it. Another person, Damien, writes, get experts in the software. Absolutely, absolutely. That's a really great point, right? And one that people are beginning to raise. The idea is that if we could make expertise in the software itself and in the systems, and if the agencies that are using them understood them fundamentally, well, that would do a lot. That would do a lot to address this concern, right? And so people like me and others are trying to ask, how do we get folks like you to work in places like that? So, you know, how do we make sure that officials have the right mental models? Making the process of appeal much more accessible, Evan says. Yes, totally, right? So by addressing some of the systemic issues around, rather than having to have Kevin DeLaban and his team comb through all the code line by line and go through the databases one by one, have there be a way, as Michael and Evan and others are saying, and Trent, to require that these systems be much more transparent and obvious, because that would help, at least it would help at the level of trying to see where they were going wrong, right? Mike also says, change implementation of such, of the edge cases and rulings near decision boundaries, the algorithms are handled by humans rather than algorithms. Yeah, the other thing too, and this is something that I've been exploring sort of since, has been, you know, one reaction that you sometimes get is for people to say, well, you know what, if governments are going to behave this way, they shouldn't be using this technology at all, right? NIVI exactly, develop human AI teams instead of entirely automating with algorithms. So I'm about to address this exact point. Some people are saying we should take this stuff away from them. They shouldn't be able to use technology. But Danielle and I do not think that's the answer. We don't think that denying 21st century tools to the government is a good idea, because the government is already behind and inefficient. You know, this is not in the paper, but it's like, it's amazing to me that, like, if I park, I can just use an app to pay like in 2 seconds, or if I go buy something, I can just take my phone and tap it or whatever to pay for things. And yet, if I go to the DMV, Department of Motor Vehicles, to like renew my registration, I have to pay with like a cashier's check, right? I mean, it's extraordinary that how far behind these government agencies sometimes are. And denying them these tools entirely doesn't strike us as a good idea. But we end up arguing that if you're going to allow government to use software and automation, it should be done in much the same way as Nivi and others are saying, and Howard is saying, which is that it should be done where the decision-making process is enhanced and ameliorated by having human and AI teams, or human and sort of software, in essence, working together, if that's a coherent way to talk about it. But the basic idea is that you find ways of enhancing policy and decision making rather than committing it to automation. And you have, exactly as Howard is saying in the chat, human oversight teams to evaluate software performance. So the basic idea here is that the lodestar, or the guide, or the guiding sort of metric for whether government should adopt technology, would be things like, does this enhance expertise? Does this make the agency more nimble and dynamic? And so as a follow-up to this paper, on my own, without Danielle, I wrote a paper that's coming out in Duke Law Journal. This one's in Emory Law Journal. In Duke Law Journal, that is talking specifically about what the benefits might be of actually modeling human behavior. You know, we can sort of get into those weeds. I think you'll be much better positioned than I will be to talk about it, but I'm talking mostly about sort of economic or agent-based modeling, wherein you can try to use these systems in order to model the impact of legislation or rules in advance, which is something that, hold on a second, I'm so sorry, one moment. Sorry about that. I told Denise and Emily this, but because the Seattle public school system has decided in its wisdom, speaking of giant bureaucracy, to cancel all school on Friday for every kid. I have my 7-year-old in my office here, and so she had a question. But the basic idea is that I've been thinking since this paper about ways that the government actually could use these tools to be more effective at governance. Right, but I do want to draw your attention to an analytic distinction, which is that some of these interventions are aimed at making the process more transparent to people who are trying to challenge individual decisions. So some of these things are things that people have, like, so for example, there was a team of computer scientists and law professors who wrote a paper a few years ago in Penn Law Review called Accountable Algorithms. And they were going through, this is like Josh Kroll, K-R-O-L-L, and colleagues. And they wrote this paper talking about how could these systems be designed with accountability and ability to challenge and due process in mind. And they had these specific technical ideas about how that would be done. But I want to draw a distinction between that and the thing that Danielle and I are trying to say in this paper, which is that at a macro level, what needs to be shown is that these agency officials continue to have the expertise in the ecosystem, the expertise in what they're doing, and the nimbleness to respond to change that justifies their very existence under the constitutional system that we have. Okay, honey, I'm gonna have to deal with that afterwards. Okay, because I can't do that right now. All right. So let me just pause there and see if there are any questions, which you're welcome to put into the chat, and I will address them to the best of my ability, or any comments on what you're hearing me talk about. I know I'm throwing a lot at you, and some of it is way outside of your discipline. And so if I can unpack anything for you there, let me know, or anything else. Does anybody have any questions or comments? Michael.
Yeah, thanks. Just really a comment. So I appreciate that you're saying that as they automate, they lose the expertise justification. But do you see any credence to, increasingly without technology, they are not being nimble and responsive, as you mentioned about the DMV, and so losing their justification that way? Any credence to that argument?
Yeah, Michael, that's a terrific point, right? And so, right, I mean, at some point, the government just gets left behind. I mean, if they don't understand these tools, it's not just the ones that they, and they just got left behind. So, for example, there was a period of time when folks working in financial regulation, especially overseeing, trading, were really behind the 8 ball, or whatever you want to say, when behind the curve, when it came to high-speed trading algorithms. You know what I mean? I mean, they just didn't know what to do about it. I mean, talk about not being nimble enough, not having expertise. There were whole markets that were being destabilized by high-frequency trading, algorithmic trading, and they really had to put in a concerted effort to understand this space better. And then they had to bring regulatory innovation to bear in the form of things like delays and ways of monitoring dynamic markets that were pretty extraordinary, and have apparently helped to really very much alleviate the problem. And so there was that growth. And so if at one point, yes, governments are going to get left behind, and so they need to move into this. They're hampered by a lack of access to expertise. And I think a lot of different, especially the federal government, the agencies, Congress itself, the White House, they're all thinking about how to get more expertise in the door. But gosh, there isn't enough, and nobody really thinks there's enough. The other area that I've explored in my work, where, and I think, because in my piece modeling through, which I did not present today, but in this follow-up piece to the automated administrative state, I argue as a solo author that right now agencies are being expected to do things like cost-benefit analyses and impact assessments, so that when they're going to pass a regulation, they have to figure out what the impact is going to be on the national fisc. They have to figure out what the impact is going to be on certain values like privacy and the environment and small businesses. And Michael, the way that they're doing it now is like checklists and back of the napkin, and maybe there's an Excel spreadsheet in there somewhere, right? Meanwhile, the way that people building airplanes, or people investing money, or people doing literally anything else in any other walk of life that's consequential, are building complex models, and just to try to ascertain what the impact will be of this change on the values that they care about. And so, I advocate there. I say that at some point, we ought to be awfully disappointed and expect a lot more out of our governments that these tools being available. So ultimately, Michael, I see kind of a tension there. On the one hand, we should expect more of government, and just as you put it, for them to remain expert and nimble, they need to understand technology. On the other hand, I identify in the modeling through paper a number of perils that come from trying to model human behavior and expecting that you're going to get, better, let alone optimal results.
No, thank you. And it's interesting in some of my experience. I think part of it goes back to how the government, in often cases, how they acquire things. Their incentive, they contract out to the private sector to get widgets and things, and so that's what they're pushed to do. And yet, when they contract out for these algorithms and all this like technology, they think they're just getting a widget that they can kind of use, and the IP that the private sector is, protecting how the algorithm works, and yet that how the algorithm works directly affects how that then government agency does their job. So interesting tension.
Yeah, absolutely. And indeed, a few people have in my world have begun to write about in the past few years about how procurement is a form of policymaking. So like Deirdre Mulligan and Kenneth Van Bauer and Kathy Crump, all of them are at Berkeley, have written about this separately. Carrie Caglianese just wrote something about this with I want to say David Lear. Anyway, point is that people are starting to realize like how important procurement is, right? And how important it is that the government not just specify the functionality that it wants, but also specify that these systems have the qualities that you have all ably identified in the chat, right? Yeah, but I think that with procurement, again, what you need is you need trustworthy expertise that can tell you, like, are you being sold snake oil? How does this really work? You know what I mean? And then if things go wrong, like how to address them and what functionality is missing, and can the architecture really perform in the way that it's being advertised? You know what I mean? And so that takes engineers being in the room, and so a lot of my work, sort of more on the impact service side, it has been thinking about how we can encourage engineers to go into policymaking. And Howard had a student that worked with my lab, who was an incredibly good example of this from your department, and she decided that she was going to take her electrical engineering training and then go and work for Congress. And now she does policy within a huge company. More people like that is what we need. And so I think your department is super well positioned. To the extent that your students wind up having an interest in policy, there's an incredibly deep need for technologists who are policy savvy and willing to talk about policy. Other questions or comments? Shashanth asks, can prediction of human behavior from AI-based software come under legal purview? Thanks. Yes, I mean, so the way that I've been thinking about this question has been from the perspective of, can the government use modeling to improve policymaking, and what kinds of pitfalls does that create? And I identify a bunch of them. One of them is that it's really data intensive, and so you might need to sort of violate people's privacy more to find out enough about them in order to model their behavior to predict how what effect the regulation is going to have. There's also kind of like a lot of subjective decision making that goes into models that may not be so obvious to the public. And so, for example, it's certainly the case that SimCity, that game that modeled economic and social development within cities and let you build a city, it's certainly true that like it was really entertaining and interesting and useful, and that indeed it launched a whole generation of people who wanted to go into urban planning. But at the same time, SimCity was a model, and an imperfect one, and embedded all kinds of assumptions about economic and social dynamics that were, when really laid bare, somewhat controversial. And so, I worry also about the fact that models will appear objective, but in essence, be the function of value judgments that are hidden away from the public. And a number of other things, right? And so I'm thinking about sort of what are the downsides, what are the concerns about using modeling more, computational modeling. It's fine if it's the weather, right? But it's not so fine if it's sort of people. But I think the question in the chat goes to, what about if the private sector or something uses prediction? And then, yeah, it depends on, so in our world, it depends on sort of the legal regime that you're talking about. For example, if you model safety gains and you're wrong, then you could, and your device that you make hurts somebody, that could lead to legal liability. If you model people without their consent and you use it to show them advertisements, that could run into privacy problems. If you model health outcomes and end up misdiagnosing something or recommending the wrong treatment on the basis of some kind of modeling that you did, that too could subject you to liability for medical malpractice, right? And so, depending on the kind of sector or activity, prediction of human behavior from AI-based software can absolutely come under the legal purview. It just depends on whether or not you have another kind of underlying obligation, right? As far as I know, in the United States, it's nowhere illegal exactly to use, software to predict behavior. Whereas in Europe, there's something called the GDPR, which is their data protection law, that actually has provisions that are specifically about making decisions about people on the basis of automation. And it even says that some kinds of consequential decisions about you, like whether you get a loan, you have a right in Europe to have that decision be inspected and made ultimately by a person. But we have not gone that far in our system. Other questions, either live or in the chat. These are terrific comments and questions, I will say, from my view. Can anyone tell me, if you're willing, has anyone had any on this Zoom had any experience with trying to model human behavior? Like, for example, I know that Sam, I think might have seen Sam Burden on this call. Like, are you using machine learning or other techniques in order to try to build models of how people will behave in order to have efficiency gains or safety gains? One of the examples that I came across in my own work was like trying to model pedestrian and vehicle behavior so as to more efficiently and dynamically time lights and crossing, you know what I mean? And so I wonder if anyone has any experiences with agent-based modeling or other kinds of modeling that they want to share, and especially whether you've come across like particular advantages or pitfalls in doing that work. Nobody wants to volunteer about that. Well, otherwise, I'm happy to answer any more of the questions you may have, including, by the way, about some of the things I work on in the University of Washington. As Howard knows, because he's affiliated, I have something called the Tech Policy Lab with colleagues in computer science and information science that work on policy issues of emerging technology. And then I have another center that I'm a co-PI, which studies specifically misinformation and disinformation, which is called the Center for an Informed Public. And that bridges information science and the College of Engineering and Human-Centered Design and Engineering through Kate Starbird, and law, and we look at misinformation and disinformation. And I used one of our examples of the work of the center in my own work, and it was specifically that my colleagues in the center, what they did was they used Twitter traffic and they examined the viral misinformation. And what they did was they modeled the impact of different kinds of interventions on Twitter, slowing things down, blocking people, attaching warning labels to misinformation. They modeled all these different interventions to see how effective they would be in preventing or slowing down the spread of misinformation. And what was so interesting about it was one of their takeaways was that these interventions don't do very much by themselves, but that in combination of at least three, it actually begins to have a significant impact. And that was something that they could turn around and then show to policymakers, hey, if you're looking to address, disinformation on Twitter, you need to require multiple interventions, not just one, in order to seriously affect the dynamic. Could you comment on the curriculum implications for undergraduates and graduates in engineering, and how would you suggest the students best obtain exposure? That's a terrific question, Denise. Thank you for asking it. One of the things that we have been studying at the Tech Policy Lab and that I've been thinking about a lot, and I know that the deans of other schools have been thinking about as well, the deans and chairs of other schools, is how do you make sure that someone who's an information scientist or an electrical engineer or a mechanical or aeronautical engineer or a computer scientist, how do you make sure that such a person who is coming to us for technical know-how, to learn methods, to understand systems, how do you make sure that they're exposed to a policy or ethics context for what they do, right? And it's non-trivial. And so, one of the things you can do is you can try to build such questions into your introductory courses. And so our colleague David Hendry, who's at the iSchool, has developed these great modules for doing tech policy. And what's really cool about them is that they're designed for a person who, like perhaps many of you on this call, is totally interested in policy, but maybe has no formal training, and yet rather their training is in something like electrical engineering or computer science. And so these modules are designed to be able to be plugged into your curriculum so that you sort of spend a day or two talking through the module, and that will help your students begin to understand the larger context for what they're doing. So that's one intervention, which I think is just terrific. And I can actually, maybe even, if I can quickly find it, I can put it in the chat. So the other thing is, I have been personally thinking about how do we get enough teachers so that people can, how do we get enough here? Hold on a second, they're right here. I'm going to put these in the chat because I think they're really useful to have. So how do we get enough teachers who then can meet the demand? This is a PDF, just so you know, it'll open directly into a PDF. How do we get enough teachers so that we have like an army of teachers who are able to come in and actually teach courses, so that each unit that wants to can expose their students to like one or more courses about tech policy and ethics. This is terrific, Ramona. And one of the ways we're trying to do that is I'm doing a course in the spring that is a Teach the Teachers types course, where I'm going to invite graduate students from different departments to come in and learn from me about how I teach tech policy and ethics, and to try to equip them with some case studies and assigned readings and things like that, so that they can then turn around and build their own, and are empowered to build their own curricula and bring that back to their home department. And so that's something we're starting to sort of think about. This is going to be cross-listed between law and information science, but there may be opportunities for electrical engineers to get involved. And the basic idea is just, how do we create a critical mass of people capable of doing this instruction? It's analogous to the question of how do you get enough people with technical expertise in government to make use of the tools. Denise, I think we're at time potentially, or are we close? Or how much time do we have?
We are at time, but students who are interested can just hang out and continue to ask questions. Usually we don't cut it off when students are still interested. And we
okay, great.
have your time, and I know you have other obligations today. And thank you and your daughter for being so great and allowing me to give you this presentation. So if you all need to go for any reason, please feel free to do so. Discussion prompts will be posted this afternoon, and thank you for your patience. But if you want to hang out and talk with Professor Calo, feel free to do that as well. Thank you so much for coming today.
Thanks, everybody. And I'll hang out for a few more minutes, and then I probably have to jump because of my visitor. So any other questions or thoughts? I'm truly happy to talk more if you do. She's listening to an audiobook. She's fine.
Yeah, thanks for the talk, Michael. Here again, another question. So, do you see, in terms of how government should appropriately implement this automation, is it more just a matter of government hiring the expertise to kind of bake in the automation skills in the agencies, or is it just changing the implementation of the automation and like adjusting how they acquire it, or is it kind of a balance of the two?
Another great question. What I would say is that the first and primary thing I'd like to see happen is for these agencies, either each individually or in combination, together. I've been part of some convenings that have brought agency managers from very different departments together to talk about AI, for example. But the basic idea is, Howard, I don't remember, were you at that convening we did at the NSF convening that Lynn Parker and I did years ago? I forget if you were, but it was about with robotics. I don't think we knew each other then, actually. But the basic idea is you get these agency people in at the same time, and you come up with an intentional strategy for when and where to deploy artificial intelligence. I think the way it's happening now, or just just generally where to automate, where to use software. The way it's happening now, Michael, is that like somebody over here hears that, hey, there's this way to do this thing and people are doing it, and hey, and then they go and they have a conversation and they say, well, here's what we do, could you automate any of the things that we do, and they say, oh, we could automate that, and then they do a pilot and it doesn't work, and what what I mean. And so it's like this really haphazard, unintentional strategy. So I think the first thing that needs to happen is the government needs to think about where are the places that we feel that this set of tools could actually be useful. And I think it's not incumbent only on government, but commentators like myself to surface those things. And so, for example, I've argued that one place to look is cost benefit analysis and impact assessment, right? I mean, if you're doing impact assessment in this completely indefensible way that's totally back of the napkin and like basically made up, would it be possible for you to formalize and indeed rely upon software to help you model the impact? And that is being done in financial regulation. And so before big macro financial regulations occur, or even before the Fed sets rates or anything like that, they do this economic modeling that's pretty damn sophisticated about what they believe the impact will be on things like unemployment and inflation and so on, right? And so that's one place. But I think they need to be delivered. Then once they figure out where are the places where there are opportunities for us to do our job better, to be more expert, to be more nimble, but just in generally to enhance our abilities, then they may want to go out there and either build the expertise in-house or partner with somebody else, and they can figure out whom to hire and what procurement protocols are in place. One place I am seeing that happening, Michael, is in enforcement. So the IRS or the EPA, they're using machine learning to look at their existing data to try to figure out enforcement priorities. So the IRS is looking at its data and saying, where do we see fraud most? Oh, it looks like it's in this sector under these conditions. And let's go and make sure that our investigators are looking in that area. You know what I mean? Or the EPA is saying, what kinds of chemical combinations seem to be the most toxic in the smallest amounts? And then they run a bunch of machine learning models on that basically improve their toxicology. And I think those kinds of things are defensible, especially if they came in and said, gosh, we're being too haphazard in our enforcement. How do we use contemporary tools to improve upon that? But I think instead what's happening is they're just overwhelmed. They don't have enough resources, and someone sells them this bill of goods of, hey, if you just have this software automate this for you, you won't have to send out all those nurses. And instead, they don't have to send out all the nurses. They just have to hire a bunch of lawyers when they make mistakes and get sued about it.
Yeah, no, I think it's that's good insight. So I worked in the federal government prior to this, and so I have some experience in this at DoD. And like what we saw is like the expertise is so hard. You can't just sprinkle this at a lot of different places because it's hard to get the expertise as well as the infrastructure required to develop these algorithms. You need the compute, and often cases the cloud, all the data, get the data in one place. And so if you can't sprinkle it everywhere, you have to essentially go out and contract for it. And so it's really critical in how you acquire and contract. At the same time, though, the private sector wants to protect their IP. So it's a very interesting balance in terms of how do you ensure you kind of know what you're getting, as well as ensuring the private sector the companies can still exist and make some sort of profit so that they can continue on. So at the same time, while trying to get the expertise in-house. And so you kind of have to centralize it to a certain degree initially. You see in the DoD, like the Joint AI Center, it's like, because it's so hard to sprinkle about, because the resources are so difficult to put together. So it's just a very interesting, I think acquisitions has a huge, at least on the government side, it's such a huge part of it, and writing the contracts and what you make the, so I see it until you can hire the internal expertise, the acquisitions as a very critical piece to it.
You know, Michael, I would love to talk to you more about this, because I've long thought that it might be interesting to say, you know, technology and government, you know, what we can learn from the Department of Defense. You know, because the truth of the matter is that the Department of Defense cannot afford, you know, should not be able to afford not to integrate the most recent technologies, even if they're in the private sector, because it's so important to have that technical edge vis-a-vis other rivaling nations. Do you know what I mean? And so
Yep.
I've seen a tremendous amount of expertise within, you know, frankly, within DoD. I also have met with the then director of the CIA, John Brennan, and talked to him about how the CIA thinks about technology. I met with Admiral Rogers, who was the head of the NSA, about how he does it. Kevin Chilton, who was the Joint Cyber Commander, came here and gave a lecture on deterrence, cyber and nuclear deterrence, and we talked to him. And that's a high level of sophistication, you know what I mean, among those departments. And you do not see that outside of DoD as much, and you certainly don't see it at the states. And so, and I think there's probably an intuition in the defense and intelligence community to keep that stuff close to the vest, right? But if there were declassified ways of talking about lessons learned from defense and intelligence, I think they would be really worthwhile.
Absolutely, I definitely think there are. I mean, just these, you know, part of the role of the government, you know, you want to, you know, mitigate catastrophic risk. And, you know, they have a regulatory role. So this technology, in order to properly regulate it, to mitigate catastrophic risk, you have to know something about it. And so if the government just sticks their head in the sand, you know, it helps no one and just increase risks to the public, as well as the DoD has a role in, you know, ensuring some sort of technological, you know, edge and military, you know, capability in order to do their role and defend the homeland. But yeah, thank you for the talk.
Sure.
I'm very interested in it.
Yeah, follow up with me. Please follow up with me at some point. I think it'd be great. I also think you'd like this conference I mentioned to Howard, that Howard's on the longtime program committee member of, which is We Robot, which is the premier robotics law and policy conference, at least in North America. And then Denise, I don't know if you'd be the right person to talk to about this, but you know, I would love to talk to you more about your department and how we can solve some of the issues that you rose in the chat, which is around how do we expose EE students to like law, to policy and ethics, you know, and if you were willing to, I would love to think that through with you and your colleagues in EE, you know, because I think it's a really important question.
Well, I think it's a challenge for me as a teacher, and I think it's a challenge for students. You know, I'm teaching a non-mainstream course this quarter, and students have come to the table and I've come to the table, but it has to be handled carefully. And I'd love to see some of this curriculum on policy delivered in a way that draws students to the table on the issues. Because when you feel like there's nothing you can do about it, it's hard to engage. So sure, I'd love to follow up and chat about this and bring in the appropriate people as well. It's awesome.
Great.
Thank you.
Sure. And I put the modules in the chat. And when I have a description of the course that I'm going to teach this spring, I'll also send that your way.
Great. That's awesome.
I'm sorry to do this, but I think I probably should hop off because Ramona's been very patient for a second grader. And so, but I just want to say again that I really appreciate this opportunity. And Howard, it's so good to see you. I hope we can connect separately soon. But thank you very much. Thanks, Denise, for inviting me, and to your colleagues. Thanks, Emily, for helping to set this up. Appreciate it a lot.
Great, and thank Ramona from us for being so good.
I will. If you can see that she's being super patient. She's drawing something on my little board right there. Romy, you want to say hi to them? And Romy, you want to say hello?
Hello.
Yeah, she's been very patient, but I think I need to give her some lunch. Okay. All right.
Okay. All right.
Thanks, everybody.
Thank you. Cheers. Bye-bye.